says, out of curiosity, did any of the panel see Breyer's recent Old Man Shakes Fist at the Sky article about originalism? Yes. Basically, him being grumpy at it and yelling his wishy-washy style is best, plus book promo. Yeah. Did you guys see that? Did you guys? I mean, I don't know why anyone would.
That's kind of his. That's just what he does, right? I mean, certainly he does it on the gun cases that I read.
Right.
I haven't seen a recent case from him on that, but that's his normal practice now. I mean, he's in the minority. That's what he does. He whines.
Yeah, and he always has. And I love this concept, like, well, originalism is dangerous thinking. It's like, well, originally they thought that you guys wouldn't have the power to do this, and that this would be done by the legislature through the amendment process, or by the states through convention, a constitutional convention. But that's how we would amend this thing. But now you guys have just over abused this ability to change the Constitution on a whim and just read stuff into it. And he's sitting there talking about the virtues of like this idea of a constitution that changes with the times. It's like, if you have a constitution that changes with the time, you have no constitution. Like,
well,
that's it.
And with the left, it's always the ends justify the means, right? So whatever their desired outcome is, that's what has to happen. And anything that interferes with that is societally negative. So the ends justify the means, and the means de-justify whatever ends are inconsistent with achieving those means. And if that happens to be the U.S. Constitution, then the Constitution's a problem.
Well, this is the problem. I actually did a lot of thinking. I had a friend, actually on American law courses, our evidence professor, Ryan Bellinger, and he's one of my office mates, and we have these great long discussions, philosophical discussions about stuff. And he asked me one time, am I an originalist? And that was quite an extra, because the easy answers say, well, I'm on the right, I'm a conservative guy, and so yes, I'm an originalist, right? That's the easy kind of team conservative answer. But I don't like giving team answers, and so I thought about it quite a bit. And my initial response to that is it's necessary but not sufficient. Because if you're looking at the Constitution, when you're looking for a constitutional interpretation, the first place you should go is the text of the Constitution and the history that surrounded the adoption. That's what I would call a originalist view.
Sure.
But if you limit yourself to that, I think that is insufficient, but you have to start there. And so we have this dichotomy. If you're a pure originalist, that is a recipe for tyranny, just like somebody who is, it's a living, breathing Constitution, and I'll just project into the Constitution whatever I want, whatever the whims of the day, to hell with the text. That is also a recipe for tyranny. So you have to really be careful. It's a difficult and high bar that we have for our judiciary to interpret our Constitution.
It ought to be.
But sadly, we get into this team sport kind of lawyering, and it diminishes us. So I do have a very strong view of originalism as a necessary but not sufficient basis for constitutional interpretation, if that makes any sense. I don't know. I'm just winging it here, but
no, it is interesting, because it is easy to call yourself an originalist. Even the big originalists, Scalia and Thomas, have their moments when originalism just kind of disappears for a minute, and it's like, well, okay, why now? Why is originalism not appropriate here? And I think there are answers to that. I think that you can say, well, look, originalism doesn't apply here because X, Y, Z. I don't know that they're the best answers. The easiest answer to give without being a Supreme Court justice is just say, no, originalism always works and you never have to ask, because you can always amend the Constitution. But it doesn't really work out that simply in practice. So I generally look at things as an originalist because, again, they made the amendment process. But now we've had, 200 plus years of non-originalism. So we have to sit here and go, well, even if you're an originalist, all these assholes before weren't, and the Constitution and the application of it has been molded by non-originalism. You can't just unwind that by being originalist now, because different expectations have been created, different understandings and different jurisprudence all exist because of non-originalists. And that's peeling it back is difficult.
What I'm saying is when you start a constitutional analysis, and I do legal briefs involved in constitution. In fact, I've got a cert petition right now for the U.S. Supreme Court.
Steve wrote a book on that.
I wrote an article on that. So I have a cert petition right now, and it's a constitutional interpretation on the excessive fines clause. And so, okay, when you're looking at the excessive fines clause, okay, I've got this fact pattern, right? and then I've got this text from the Constitution that's handed down from us from back in the history. Well, how do I start writing my brief? Do I just start writing whatever I want it to say?
Yes.
Just ad hoc. That is completely unhinged from any kind of, I think, rational thought. I think you have to start with the text and then look at the history that surrounds why. And there's some documents. There's the Federalist and the Anti-Federalist papers, and there's discussions. There's early court interpretations. You look at the history of it. You start there, because if you don't start there, you're just building something out of nothing. But if you stop there, then you run into all these problems. And Andrew knows this dealing with guns. You run into all these problems with, well, there's no muskets. Muskets are the guns. And so we don't evolve into handguns and rifles and from flintlocks if you're just sticking with originalism, right? So there has to be a balance here, but starting with originalism and progressing forward.
I gotta disagree there a little bit, because just because they're talking about rifles and flintlocks doesn't mean they're not. They didn't say
it
guns.
says arms.
Yeah, it just says arms. So whatever an arm is, right? Like, what are arms? Arms are commonly understood at the time to be weapons of some sort.
Any means for offense or defense.
Ooh,
see there now. I knew this.
That means my mouth is an arm.
So it would include, for example, body armor.
Right. Yeah. And I've actually, you think that might sound ridiculous in the consideration of arms, but of course you hear news stories about a mass shooter. It's like, or about a suspected mass shooter, about some crazy person. They're like, and he had several sets of body armor. It's like, well, so like, what's he going to go do? Defend himself to death? Like he's just going to body armor, like, let my plate carrier kill all of you. I don't get it. But that's how they always talk about body armor in that way. That somehow indicates they're the next level of insane. Well, or just they wanted body armor for literally any purpose. Maybe they're scared or paranoid, or maybe they just have it for fun. I just wear body armor.
The problem is, if you do a proper constitutional analysis of the Second Amendment, like was done in Bruin, virtually every gun control law in the books is facially unconstitutional. And that shocks the left conscience. They simply cannot accept that. That's why we have these appellate courts in open rebellion against McDonald, Heller, Catino, Bruin, just spitting. You read these opinions, it's just word salad. It's not legal reasoning. It's just the words they have to say vomit out in order to come to the conclusion they want.
Well, yes.
And a reality of all this, of course, is that the Supreme Court is a political entity, just like the rest of the government is a political entity. The Overton window is not infinitely wide. You have to kind of push it over by inches. And that's why we get, like, even in Bruin, or maybe it was Heller, McDonald, I forget, but they were like, oh, no, this is an individual right to keep and bear arms. And then in a footnote, they say, but of course, concealed carry licensing regimes, we're not saying those are unconstitutional. They didn't say they were constitutional, but they said, we're not saying they're unconstitutional. So the leftists grab onto that. But if you look at the history and tradition of the Second Amendment in America at the founding, there was no permitting process to keep and bear an arm.
Because one, how would they have tracked it? Two, how would they have tracked it? Everybody had guns. And going back, when you think about the founding, I mentioned this on the stream the other day, just like trying to get a kind of a story, a picture for people. Like, you would send your 11 or 12-year-old into town with your cart and groceries to go get groceries for the family. If you lived in a rural area, they'd go into town several miles with a horse and a cart. They come back with like a week of supplies. And one of those supplies might be a new rifle, a new shotgun or whatever that they buy from the general store, ammunition. And there was no question that some 12-year-old would be buying a rifle and a box of ammunition or a musket and a bunch of steel balls and gunpowder. Like, they'd be buying that and then going back home, and they'll be like, well, you're only 12. Like, that wasn't the thing. Or
when I was a kid, when I was 9 years old, living in Florida at the time, 9 years old, I lived in a part of Florida. Well, it's all built up now, of course, but at the time there was nothing. It was wilderness. And I had a 22 rifle. That was mine. I would just take that and a brick of 22 long rifle ammo and go out into the woods and just plink stuff. And no one thought anything about it.
Right.
Yeah.
Yeah, same here. Actually, I remember that also. Although pushing back just a slight bit on y'all, and I'm very pro Second Amendment, but there is that initial clause that says a well-regulated militia being necessary for the existence of a free state. So what does the well-regulation mean? I think that would we argue that let's say the criminally insane should have access to any kind of firearm.
No. The founders always agreed that the unlawfully violent, you could not carry arms for unlawful purposes, or if you were insane. I mean, they had constraints on what insane people could do. They're talking about what law-abiding, mentally sound American citizens could do.
Right, and it's firearm.
The founders had lots of laws against unlawful carrying of arms for unlawful purposes. There were many laws against that.
But for lawful neutral purposes, because that's the trick. People get into a sort of positive necessity in rights. It's like, well, they're carrying around for a lawful purpose. Well, what people tend to mean is like, well, I'm going to go shoot like a deer during hunting season or something like that. There's a purpose to it. I'm going to go to the range because that's I'm going to practice. I'm going to practice for the militia. That's a lawful purpose. But the lawful purpose that people often miss is the one that's stated: keeping and bearing arms. Keeping arms is a lawful purpose. Bearing arms without pulling a trigger is a lawful purpose.
But
absent contact
and pulling the trigger can be a lawful purpose when protecting the lives of innocents, the lives of your family. You know, and even the defense of freedom against a tyrannical state. Although, you know, we don't like to talk about that because that's the trap that the left sets for somebody who's in a rhetorical argument to talk about that. But that is one of the bases and one of the reasons for the Second Amendment is to protect the people from tyranny. And as an example, just look around in some of those people that were killed in Israel that were living in gun-free zones, or the Russian theater. They're living in a police state. They're in that Russian theater, and they're being protected by their police state. And then these guys come in and machine gun them down. So it's like, was the state protecting them there? To me, individual self-defense it's almost the right to life itself.
The state protects the state. The state doesn't protect individuals.
Exactly.
So to answer your English question, Mr. Gosney, I would suggest that the initial clause is merely a suggestion as to why the second clause exists. The operative clause following the prefatory clause. So a well-regulated militia being necessary to the security of a free state, semicolon. It doesn't say because therefore. It doesn't say since we need a militia, we need to have gun ownership. It was like, here's a reason that is plausible and legally defensible in a government interest type of way. Well-regulated militias are necessary. We need to have everybody be able to have guns free of regulation. And they wrote the Commerce Clause. Like, they knew what they wrote, that the Commerce Clause would allow the federal government, would allow the federal Congress to control through commerce anything that traveled interstate. And at the time, you did not have, I would suggest you maybe didn't have like this diversity of manufacturing. Like, you're going to be importing guns from Britain, right? You're going to be importing guns from Europe.
We're mixing issues a little bit, because I think that the Commerce Clause expansion is a real weakness, I think, of our current Constitution, because of the expansion of the internet, the marketplace has gone. In fact, Clarence Thomas, one of the things that really impacted me is when I heard him speak, and he talked about the Commerce Clause, and he pointed to a little piece of plastic on, or like this little object right here, this little thing that you put your glass on, right? Is this in the stream of commerce? Because if this is in the stream of commerce, everything's in the stream of commerce. Whereas before, during the original, if you talk about an originalist perspective, it would take, counties were one horse ride over, and states were many weeks journeys to go along to. And so the regulation was simply a matter of coordination between states. Whereas now the federal government can regulate everything through the Commerce Clause.
Right. Wickard versus Filburn definitely expanded the Commerce Clause. It added the dormant commerce concept. They call it the dormant commerce clause, but the dormant commerce concept is that you can participate in commerce by not participating in commerce, effectively opening the door almost, except thanks for the one good thing John Roberts did, was he partially closed the door on compelled participation in commerce through the Commerce Clause. But Wickard almost kicked open the door, but it effectively said, even if you're not going to purchase stuff because you make it yourself, you have participated in commerce. But yes, I agree with that expansion happened. But remember that at the time, you don't have a gun manufacturer in every state. In fact, most of the arms I would suggest are probably imported from Spain, France.
You mean at the
England?
time of the founding?
At the time of the founding. So when they're writing this thing, they know that the federal Congress can regulate effectively all firearms coming in through not only the Commerce Clause, but also the Import Clause, right? No excess duties on imports, except by Congress can do that, but the states can't do it. So you have this ability for Congress to regulate this thing, and they go, actually, you know, that this is a lot. They can regulate a lot, but we really don't want them regulating this. We don't want it. 1, tyranny. 2, militia. 3, everybody's got them. Everybody's got guns. You need them. You're a frontier society. You're expanding into wilderness that is occupied by savages to them, right? And these your people expanding out are going to encounter not only wildlife and other turmoil, they're going to encounter native people who might be hostile or might not. And so the ability to own a gun it's necessary. And again, I would suggest it's near ubiquitous. I would suggest it's more ubiquitous then than now. It's just that we have individuals owning more and more of a hilarious arsenal than we had back then. But.
Yeah. Also the fact that, I understand the hunting and the frontier aspect, but also the founding fathers saw tyrannical government as the threat that it is. Government has killed way more people than criminals.
But even the Bruin Supreme Court won't talk about it in that context, Steve. Even the Bruin Supreme Court, they talk about the Second Amendment in the context of self-defense. They will not talk about it in the context of tyranny.
I understand that, but I don't want to lose that.
I think you're right. I agree with Steve Gosney.
That's one of many arguments, but to lose, if we fight the hunting battle, it's like, well, who needs an AR-15 for a hunting rifle? Because loses the context. There are many reasons for firearms, and riot, civil disorder, government withdrawing its police protection from an area and creating civil disorder. You see that a lot of tyrannical governments do that. They use the criminal underclass as a weapon against the people. In Venezuela, for example, they would withdraw police protection, and they would use that to cow the middle class. So it's not just active tyranny; it's a passive tyranny of allowing criminals to exist. So there must be, we saw that in LA during the LA riots when the rooftop Koreans, it's not far away, the thin veneer of civilization, and firearms allow the individual people, which are the state, we the people, to protect themselves in times of need.
The tightest permissible restriction should be whatever arms our government provides an individual infantryman is what any American citizen should be privileged.
Okay, that's an interesting, you make a point.
And I would define it broader than that, but I think that would be a reasonable threshold. Because then there's crew-served weapons, there's mortars, there's tank. But again, in our Constitution, it says we have a provision for a private navy, right? You could own a warship.
Well, I've always thought my rule of thumb, and I'm not certain. Actually, I'm glad Andrew's here because I've always wanted to ask you this, and that is my rule of thumb is if it's available to a civilian police officer, it should be available to the people.
That's everything the military can have. An infantryman can have.
To me, the military is an external force, external threats, and that's different. They get to have the nukes and the fighter planes and the bombs and that sort of thing. But as individuals, we have the same, because it's a civilian police force. So we should have, civilians have the same access to firearms as civilian police forces.
But in the last 20 years, we've militarized our police forces. So they essentially have all the weapons an infantryman would have. They have armored vehicles. They have fully automatic weapons. What's that?
They don't have bombs or crew automatic weapons.
No, but again, those are not the tools of an individual infantryman. Those are crew-served weapons. It's a next level up.
They do have they don't have bombs that drop from planes, right? But they do have bombs. I mean, absolutely.
They bomb places. What was in Philadelphia? They bombed out blocks, right? They dropped a bunch of bombs on a building.
That didn't go over real well, did it?
Police forces have explosive devices, and like, what does it become like a? Yeah, I guess if you could throw it with your hand, is it one category versus using some sort of machinery to deliver it? They use. Didn't they send an armored? Not a flying drone, but they sent in a drone down in Dallas with an explosive attached. They sent in an Islamic drone to suicide bomb that guy who was holed up in a parking garage in Dallas. Do you guys remember that?
I do remember that. Yes, that kind of got lost, didn't it? It was the wrong political incorrect perpetrators. But yeah,
That's when they make
that.
grenades for police officers. They shape them like donuts.
No, they would never throw them. No, I mean, I didn't know Boston Dynamics created the Muhammad Bot 1.0, but it like wheeled itself in there, and the guy's like behind an SUV or whatever, and it's like, yeah, you are terminated, la 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 la, and then explodes, and he dies, and it's like, wow, that's cool and terrifying. They have a bomb delivery bot. It's like Amazon, but worse.
I am a 72 Virgins bomb. I'm a 72 Virgins bomb. 71, 70, 69, 68.
But I have a question for you guys. Like, so I hear this disambiguation or whatever distinction between military, like you're saying, crew served weapons versus civilian. Or whatever. Where does this come from? Like, it doesn't. To me, I read the text and I look and I go, like, I know USV Miller has this distinction between actually kind of protects military weapons and the Heller unprotects them, which is weird. But you've got this distinction that comes from the fucking turnbuckle that I don't understand. It's like, wait, why are we talking about military versus civilian? Where is that a thing? Yes, enlighten me, Ghazni. Where's that in the text?
Well, it's in the Constitution. The Army, the U.S. Army actually precedes the founding of this country. Cool. And the Army is, the military forces are specifically delineated. The commander-in-chief, those are constitutional creations that are powers that are delegated to the federal government. So I would say that's why I make the distinction between military and police. So because
where are you drawing that from the text?
Well, this is the thing. You have to flesh out the text, just like you're saying, what are arms? I think the arms that are available to the military are exclusively external protection. When you're talking about internal policing, then I think there should be an equivalency of arms, the arms race equivalency, as we talked about. So, for example, if the police can have it, civilians should have it. If it's going to be directed against the people of the United States, it should. If it's external, now I understand there's been some blurring of the lines here, but we should definitely, if the cops can have it, we should have it. That's my point.
I completely disagree with you right now. And I'm going to use the text. Are you ready, Stephen Ghazni?
Go ahead, lay it on me, baby.
Bring it on. Blown out.
Are we back to Steve's book?
Yes.
Yeah, speaking of which.
Stephen Ghazni. A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Now, it is a plausible legal definition, as I said, legally defensible definition of why keeping arms is existing, not the exclusive reason, but it's an important one. And it does not say the internal security. The militia is not the police. The militia is the initial force repelling invasion before the Continental Army can march to the state, remembering the deployment of a battalion of soldiers may take days, but the calling of the militia could happen in hours. So we're talking about a boat landing in Georgia and the people of Atlanta gathering together with their arms, whatever they may be, to repel the invasion force until the army can get orders from Virginia, from the commander-in-chief, down to the closest battalion, I guess South Carolina, and then walk down into Georgia, or even get the runner down to the military base down in Georgia to respond to the invasion. Like, we're not talking about any sort of comparison to civilian policing in the Second Amendment. The text of the Second Amendment applies or implies the security.
There was no civilian policing
external.
At the
right. That's the other thing. There wasn't a civilian police force, but the defense from external threats.
The forces against which the militia would be directed were external. They were the French, the Indians, ultimately the British, of course, sometimes the Spanish. But it wasn't that Georgia needed to defend itself against North Carolina or South Carolina, I guess I should say. It was external forces. And keep in mind, however, what the militia really was. The militia was guys like us, right? Just farmers or townsmen, and we'd be called up and we would be expected to show up with a rifle, gunpowder, bullets, right? The accoutrements of going into the field, but probably not a cannon.
I'm sorry. I just have to laugh at what you just said. Like, if we rewind the tape, Andrew Branca just said,
"Is this going to be a clip?"
Look, the militia. Now, the militia was made up of guys like us, farmers,
Big foreheads.
I'm like 3 white collar, egghead, out of shape, slovenly men, over 40, sitting around yakking at people for a living. It's like, that's what the Minutemen and the militiamen were back then. It's definitely a bunch of lawyers walking around like, oh, well,
no,
let me talk about the Constitution.
I beg to disagree, Mr. Baldo. This guy right here, man, he is quite the marksman.
No, I didn't say that. But
I mean, if you want, I wouldn't go to head with him, man.
But he's talking about the militia being made up of guys like us, and then he talks about farmers and townsmen. It's like three white collar guys.
A lawyer, come on.
3 white
with soft girly hands.
Yeah,
girly hands.
It's like, oh my God, it's just funny to me. That's all. I'm not doubting this man's skill with a gun, but no, I do think that I disagree with you, Steve. I don't think that the Constitution draws a distinction between military arms and civilian arms. Or
well, you have a rumble rant that is calling me out and agreeing.
Yeah.
You see there? Do you see that rumble rant?
Oh, I'm gonna say it. Here we go. Go for big guy 911. Ghazni is fundamentally wrong.
Fundamentally.
all cannons, tanks, he's making an analogy, and Navy analogy battleships. Well, they were actually battleships back then. They were also merchant ships equipped with cannons as well as battleships, but were all privately owned. The founders didn't suddenly unknow this when they drafted the Constitution. Yeah. How do you respond, Ghazni? And if it isn't prostrating yourself before go for big guy 911, I don't know how you can.
Well, I would refer to Mr. Go for Big Guy 911. You think you're such a big guy, you put it in your chat. I'd refer you to the Naval Act of 1794 that authorized the original 6 frigates of the U.S. Navy, including Old Ironsides itself, the USS Constitution. So you say, then how do you justify the USS Constitution, Old Ironsides, and in that? So I don't think your categorical statements are correct, my friend.
But okay, ignore the 1% exceptions to the categorical statements.
Those are 6 ships, the USS Constitution, and the Army was raised. Now that was raised under the Continental Congress, under the Articles of Confederation. And I understand there was militia, but there
borrowed the cannons from private residences.
No, there were donated from France. Those were
Ticonderoga.
Yeah, when I was in Savannah, I actually saw they have a cannon that was surrendered at Yorktown. Amazing, all right on the walk in Savannah, and I was like, wow, that's really historic. I was telling my wife about it. It's pretty cool. Cannons surrendered to Washington and given to Savannah right there. You can check it out, touch it. It's amazing. So I don't agree. I don't think your facts are correct, but I understand that this is not one of my areas of expertise. I like history and I'm interested and I like the debate and I like the challenges because it's going to make me go out and dig some more. But the fact is that cannon were generally state operations. Those are very sophisticated weaponry at the time. Bronze casting to create a cannon is a very difficult manufacturing process. Most of the cannons that were captured at Yorktown were of French and English design. The Dolphin, which is the Dolphin, those are
French and English design doesn't mean government owned.
Well, but government created to create that kind of weapon.
Oh, the French and the English, though, they weren't government created by American government. Like the private residents, of the aristocracy purchased those from those governments. They imported them and they used them. It was funny though, because cannons aren't arms according to the law, right? Like cannons are not included in the NFA or the what should we call it, the Gun Control Act, right?
Because it's what
can you bear a cannon?
1898 is 1898
if you're manly.
Firearms created before 1898 are antiques and are not covered by the federal law. Not that we're giving.
But I don't think if you make a cannon today that it's covered by federal law. Is it? Because there's
I would be careful about that. They have a category called destructive devices, which is anything over half an inch bore diameter. So I'd be cautious about that. But I buy all my guns at gun stores. So
no, because the cannon doesn't have a rifled barrel, and it's I can't remember the reason. It doesn't matter though. But I was just curious. But I don't think it's considered in the same category. It's certainly not in the same category as like a firearm or an AR-15. And it's really it's weird because cannons aren't considered especially dangerous or unique weapons, which to me, they actually kind of are. So this exception doesn't make sense. And the funnier thing is a cannon from back then operates effectively the same as a cannon from now. Now, not a howitzer, right? Like a howitzer would have like a rifled barrel, I think, and a more direct or a more, as a result, a more accurate arm that goes with it. But cannons, if I'm not mistaken,
I don't know. This is out of our wheelhouse. I will go for big guys taunting me again. And I'll also respond that the Continental Army was created and founded by the Second Continental Congress. And so the Army predates the U.S.
What about the Navy, though? Because he's talking about the Navy.
The Navy also. Now the question is, what are the, when we get to the particulars of the firearms and the weaponry that's being used, who originally purchased it and owned it? A vast multitude of the weaponry that was used was brought into it from the militias and from the hunters, but also they were also bought from abroad and brought in because of the manufacture of the more modern weaponry. So, it's a complicated question. This is not, there aren't simple historical answers, but it's an interesting discussion historically. I mean, I like talking about this as a history buff, not as a legal commentator on this issue, because.
But if we don't remember, this all originated from a question about originalism, right? Okay. Right. Versus Breyer. And I think this is really interesting because when we get into a discussion about originalism on the right, we tend to default right to the Second Amendment because it's the most unoriginalist treated amendment we can think of at any given moment. But let's apply Second Amendment reasoning to the Third Amendment. And what conclusions do we come to, right? So what is the quartering of soldiers in peacetime if we take an originalist approach and if we limit it to soldiers of the Navy and the Army, the only two branches of the military that existed at the time of the founding? Now you have a Marines and an Air Force, but I believe the Marines are part of the Navy officially and the Air Force is part of the Army. But is the Air Force part of the Navy as well?
Air Force is a separate arm. Marines are a sub-arm.
Originally, the Air Force was the Army Air Corps, and it was split off. But it was originally there was just an Army and a Navy.
So what if you put in a modern drone striking operation inside, like they quarter them in my house because they're going to attack Canada? Like, all right, we're gonna quarter these 3 Navy men who aren't going to do, or Air Force, Chair Force guys. We're just going to sit around and do nothing but demand sandwiches while they play with their joysticks and fly drones into Canada to blow up Trudeau's friends or whatever. They're going to do that. Is that a violation of the Third Amendment? And we say, of course. But if you take an originalist approach, you go, okay, well, now there's a new branch of the military that is not, they're not soldiers, right? Like in the same concept as we're thinking of an infantry. We're thinking of officers who are commanding infantry. These are guys who fly planes or they use electronic means to pilot an unmanned aircraft into another place.
They're military. They have license from the government to take human life in a manner outside the realm of a civilian. So
I agree. I agree, but an originalist has to go through these questions, and then more importantly, we go to like what if it's an FBI agent? What if it's a CIA agent? What if it's a state police officer? An originalist looks at this and goes, well, a state police officer is not in any way a soldier. But if you try to quarter a state police, if you try to barracks like state police officers in houses like around a city to deal with a crime spree, there's no way that would pass Third Amendment muster, right? Like there's no way you could see the mayor of New York going, all right, we need NYPD stationed strategically in this building, which is a big crime problem. We've got them in multiple random rooms in a high-rise apartment complex. And they're going to stay there for 3 days, and the citizens who live there are just going to have to deal with these police officers.
NYPD used to do stuff like that. They used to do stuff like that.
Did they get ousted by Third Amendment?
They no. Well, it was with the consent of the property owners, but they'd have these convenience stores getting robbed all the time, and they'd put a couple detectives in the freezer in the back of the convenience store, and the next time the armed robbers came in, the cops would just step out and shoot them in the head.
Damn.
Yeah, that's cool. Hardcore.
Yeah, and that's hilarious. Except we go, well, those guys had rights, but it's
such a, I got to say, this is such a guy discussion. I feel like I'm with my bros talking at a bar about about stuff that we know something about, but not like completely.
Well, but but no one knows about.
I used to know some of those cops. They'd run on body counts like 10, 15, 20 people they've killed in their career. Today, that doesn't happen. A cop kills one person. He's never given the opportunity to shoot.
And they're defeated
again.
Every college chick. No, but it's an interesting discussion because Steve, I want to point this out. Like, yeah, we may not know all of the ins and outs of these concepts, but some of the concepts are novel, and the Supreme Court justices who are tackling these novel concepts, at least if I can analogize this to Trump's situation, they don't have any idea, right? Like they don't have any idea what to do with an indictment.
I think there's some really good, and now if you want to read U.S. Supreme Court decisions, you got to read them carefully because they're advocating for their ultimate conclusion.
Right.
But, a good appellate decision, like a good U.S. Supreme Court decision, should explain to you, the consumer, the people, about why they are doing what they are doing, and they should do it in a very convincing way. That is the beauty of the common law, is that we, the people, get to read the reasoning of our justices and of our Supreme Court
or lack thereof.
Or lack thereof. And no,
I'm talking about on my stream.
No, and so when you read a well-written and a well-reasoned opinion, then like Marshall did a great job on the death penalty. On which case was that? I think it was the Gregg decision.
Wait, Thurgood Marshall or John Marshall?
No, Thurgood Marshall.
Oh, okay.
And it was a very comprehensive, soup to nuts historical view leading up to the current situation. And it was a brilliant. So you can, if you find a good case and a good justice who's doing their job, they will lay it out to the best of their ability, and you will coherently and clearly see what the ideological and philosophical differences are between the judges and why they decided what they are. And that educates us. When judges play games and they're using ideology to just come to conclusions and rely on raw power, the law drifts away from the people and it becomes more tyrannical.
Yeah, I mean, I hear what you're saying.
So somebody in the comment mentioned Jim Cirillo, Tales of the Stakeout Squad. That's actually who I was talking about. I knew Jim Cirillo. He was an NYPD cop who would hide evening schoolers and shoot robbers when they came in. He died maybe 10 years ago or so. But
those
I know him. I heard these stories right from him.
Did the cops have consent to be in those businesses, though?
Oh, yeah.
So that's not a Third Amendment issue, right?
No.
Like,
right.
Yeah, so that changes it dramatically.
I just thought it was a good story.
And then the next question is, like, you're in a business, is that quartering in a home? And then we get into questions of what is a home? Is it a domicile? Because some businesses are treated like domiciles in regards to other laws. And those are interesting Third Amendment questions that don't usually have to be asked, because we don't go, we're going to just station people in here without your consent. Because usually if a law enforcement officer is being put somewhere for a period of time, it's with the consent because the person has a concern about, their safety or something that's going on. It doesn't come up that often. The point of this is these are novel questions, and the people who are answering them don't really have any expertise. Ask Madison, right? Hey, Madison, does criminal immunity exist for a president who is no longer in office, who took classified documents out of the White House to his private residence and didn't return them when asked by the succeeding administration's attorney general? And he'd be like, the fuck? Like, what Madison said? Classified documents. Like, what the hell is a classified document? Why is this a thing? Wait, what? The president doesn't have like ultimate authority here? Wait, he's taking documents from the nation's residence to his private residence? Like, that seems like a lot, because that's a long way. Oh, and by the way, that's from DC down to Florida. Like, he's like, oh my God, Florida, isn't that where the Seminoles are or whatever? Like, he does. The concepts of them are so far. So we do have to figure in some kind of interpretation. And how can you have an originalist discussion with that? Like, how can you? But similarly, how can our justices go back and go, you know what they're thinking? This is what they were probably thinking there. This is how we're going to attack. They don't know what they're talking about. They're making shit up just as much as everybody else.
Well, but this is
why I hate the legal profession so much.
Well,
everybody's making it up.
It's necessary, but not sufficient. You need to start there. Start with a text, start with a history, and then move it forward based on the law and the evolving common law, and use the best reasoning and do the best we can with what we have. I think if you're stuck in that originalist trap, That's just as much of a tyranny as is the free-flowing, whatever I think it is, leaving, breathing constitution concept. Both of those are opposed to individual human freedom. So we need to, there is a technique here. There is a rational technique. It's called the common law. And that is, we have our governing document, which gives us broad principles. We start with what the meaning is, what the text says, and then we reason using fact situations applied to that law, deciding them fact to fact, and not making broad sweeping pronouncements from on high of grand justice and grand proclamations of justice. That's a recipe for judicial tyranny. And that's where a lot of conservatives object to this living, breathing constitution, because the judges are both legislating from the bench. Instead, they should be applying the facts to the laws that exist and case by case individually.
Yeah, that's why I actually hate Marbury versus Madison. Because I believe that the Supreme Court, I believe the Supreme Court was given original jurisdiction over certain matters and then appellate jurisdiction over all of these other matters. And yet, the purpose of that was not to, in my opinion, limit it to 9 justices who would hear 130 cases a year and then disregard every other case under those jurisdictions. I think that's ridiculous. I don't think that's what the founders intended.
How many justices under Marbury? Were there 9?
6, I think, at the time. It was one of the first cases.
Even worse, right?
Right. But they didn't have as many cases, and they didn't have the ability to bring as many cases. There weren't as many federal laws and federal regulations. There weren't as many civil issues that had been developed, and there weren't as many people. But we limited it to 9 a while back, and then we said this is how the Supreme Court. Well, Marbury versus Madison says how the Supreme Court would operate. We say what the law is. We create binding precedent, and we go on from there. And now that's the law forever until we change our minds. But we actually don't go against stare decisis. We don't actually overturn our reasoning. We just find some way that is different or whatever to justify it. And
distinguishable.
I don't think that that's right, because I like what you said, Steve. Apply the facts and the law to what you have before you. And I think that's what the Supreme Court was supposed to do. I don't think it was supposed to decide everything in these sweeping decisions. Like, I don't think Chevron.
But that's not how human beings work. They don't work
I know
that
it's
way.
not, but they should, because I'm better.
This is another thing that I deal with a lot.
John Marshall's stupid.
And people don't know me. I do criminal appellate law. And so I deal with appellate courts. And most appellate courts, they just rubber stamp things. There's no opinion. There's no writing. And the problem is you get justices that say, well, there's all these books full of cases here. Why should we add to this book? So everything's decided. It's certain, right? And it's like it's all set in stone and there's nothing new to be learned. So why should we write another decision on another fact pattern? And
it's so bad. Most of their decisions in large population states, they don't even publish anymore.
Exactly.
I mean, they don't technically publish anymore.
Well,
but the crazy thing is,
we have 95% of our criminal cases are PCAs, meaning no written opinion, just affirmed without opinion. The problem with that is that undercuts the entire concept of the common law, and that is the evolution of the law through the application of specific facts to the law as it exists. So as the laws change, as fact patterns come in, you need those individual examples. When you teach a concept, you teach with a definition and a set of examples. And if you rob the definition of its examples, the text becomes meaningless and arbitrary. So we need to have courts doing that function, but instead we abdicate it into becomes this political arm, and it robs us of the richness of the common law, which is rationality.
The problem with Marbury versus Madison in this concept, to me, is you get a system by which the Supreme Court makes affirmative amendments. And all you have to do, you don't have to look far on this. Look at Roe versus Wade, right? The Supreme Court created an affirmative right to an abortion where none existed. Nothing even close to the concept of that existed. And there was no reason for the Supreme Court to create that concept. They did not need to create a protection for abortion. And the current system allows for abortion in any state. The states could do this. All states could legalize abortion. In reality, all states could legalize some level of, decriminalize, I should say, some level of murder. All of it, right? Like, think about this. If Kentucky was like, you know what? Fuck it. We're just gonna take the manslaughter and murder statutes out. We're going to take them out. Can you go and assert your right to life before the Supreme Court and require Kentucky to create a criminal statute on murder for you? No, you can't. Like, how can the Supreme Court compel a state to criminalize a thing? They can't do that.
I mean, we decriminalize murder now. We do it today. I mean, as an illustration, for example, in 49 states, if you find some guy stealing your laptop out of your car and he's walking away with it and you shoot him in the back of the head, that's murder, because you can't use deadly force in defense of mere personal property. But if you're in Texas, it's not murder. Texas allows you to use deadly force. So some people would argue that Texas has effectively decriminalized what every other state would call murder.
Yeah, but I want to take it farther, though, because a state could just remove their murder and manslaughter statutes from the books. And I don't think the Supreme Court can, since the right to life is not a positive right, it is a negative, it is a restrictive recognition of liberty on government. The government cannot take your right to life without due process, but the government has no mandate, and we know this from Castle Rock versus Gonzalez, to protect your right to life through a statute criminalizing murder. They don't have to do it. In fact, they don't have to have a statute. They don't have to have enforcement of it. They don't have to do anything. So the problem is now under Roe versus Wade, they had to create a positive protection for an act, which is weird. That's a strange aspect of it. And
I'm not sure if the abortion context is a little bit hot and political, and I think detracts from the philosophical discussion.
Well, that's why I analogized it to a murder statute to get away from the abortion context.
Yeah, because you had a really good Odysseus 17 made a really good point that I was thinking about throwing at you. Yeah. It looks like there's been a little interaction there, and he said Nick's take on Marbury Madison is interesting, but he overlooks the fact that literally all the founders were alive at the time and didn't take issue with it, including the Chief Justice Marshall himself, who was appointed by Washington and was friends with Washington and wrote the biography of George Washington in a personal manner. So I think that's a pretty good point there, Nick. Do you have a response?
Yeah, I do. My response to him in the chat was merely the effect that sort of binding precedent and the structure of the Supreme Court would not happen until much later. Right, like the effect of having these binding decisions where the Supreme Court took an extra constitutional power that was not delegated to them and said, no, we actually have the power to say what the law is forever going forward. That's not in Article 3 of the Constitution. They don't have that. They just have jurisdiction over cases and controversies under their original jurisdiction and their appellate jurisdiction, and their appellate jurisdiction can be circumscribed or delegated by Congress in various ways. That's all they have. They went in Marbury versus Madison. They went outside the Constitution. Says no. We say what the law is. Like, actually, you don't. Congress says what the law is. The president agrees with it, or Congress overrides what the president disagrees with. Congress says what the law is. The Supreme Court never does. That's not in Title 3 or in Article 3 at all. They go. That's literally in the text of Marbury versus Madison. We say what the law is. Okay. They did that to prevent the executive and the legislature from going outside of the Constitution and their constitutionally delegated authority, ironically, which I think was funny. But no, they didn't take umbrage with it for two reasons. One, the entire common law is built on this idea of sort of a snowball effect of law being created as issues come up. So I think it's kind of within their regular sort of perception to think, oh, this will naturally progress this way. But under the English system, the common law is circumscribed by the fact that you cannot bind an existing parliament by prior acts of either parliament or really the judiciary in prior time. So you can't, they can't actually bind parliament from creating new laws in England. They can't do that under that system. But here you can under Marbury versus Madison, but not under the Constitution, which is crazy.
It all comes back to Andrew Breitbart. Politics is downstream of culture.
Right.
When you have a cohesive culture, you can have a wide variety of mechanisms for the politics, and the law is politics that work because the culture is cohesive. When you have a disrupted culture like we have today, none of the mechanisms are going to work.
Oh, absolutely. 100% agree with that. That it's a very important point that we need to work on the popular culture just as much as we do, from this top-down academic, because it's we the people. and it takes individual people being reasonable and with a coherent society in order for all of this thing to work. If people stop believing in the principles of law and order and the law, and we stop following the Constitution, we throw all that out, we really are living in a post-constitutional republic. So
we only have a constitution in the first place because of the culture of the founders, right? That's where it came from.
But see, I want to point that out, though, because that is a critical difference between this is what I was talking about. There's a critical difference between England, the Parliament and the King, and the United States, and the creation of the legislature, the executive, and the judicial branches that are separated. Is remember that the Constitution is the ultimate authority. It is the primary law of the land. It is the ultimate law of the land, and it has an ability to change over time that is baked in and politically exceedingly difficult without massive unity on political will, right? And it is the binding law, not, remember, the system they come from, what the founders are coming out of.
And the founders knew what Andrew Breitbart said, right? John Adams said that our Constitution is suited to a moral and religious people, and it's utterly unsuited to any other type of people. That's just another way of saying that politics is downstream of culture.
I just got to finish this one point, and that is that all those founders came from a system that could not bind future parliaments from creating law. And when Marbury versus Madison happened, they didn't need to object because effectively it was them restating the common law. And as time has gone on, that has created a system by which effective amendments to the Constitution could be made by the judicial branch, which was never intended, not even close. So yeah, none of the founders objected because it went along with their concept of the development of the common law in the United States. They've got these justices who are going to issue opinions about what the law is, and that's what will happen. We're going to state this. This is what this means. This is the thing. But the ultimate idea was that we always went back to a constitution which would bind everybody else. Everybody, including the justices, including future Congresses. This document binds that. And that is gone because now the justices can simply say, the document doesn't say that because we say it says something different. Now, we're not bound by anything, including the Constitution, and the
of course,
judiciary isn't.
In the context of the founding, the common law did develop. It developed over time, but it developed at the speed of a glacier. It developed over hundreds of years. There's no common law inflection point, unless you're thinking of like the Magna Carta, where we had a Roe v. Wade decision where no state had ever decided that abortion was legal, and then the U.S. Supreme Court decides, no, we're just going to make it legal for everybody. That's not a common law thing.